On the night of June 27, 1997, Marcus Willis left his girlfriend's home in Indianapolis and never came back. When officers eventually opened the white GMC Yukon sitting in a strip mall parking lot on Keystone Avenue, they found him shot in the back seat. And what they found around the vehicle told a story of someone working very hard to make sure it stayed unsolvable. The front passenger seat had been removed. The carpet had been cut out. Willis's blood was on the rear hatch, the door, the floor mats, and later on the walls of a garage on Caroline Street, where the seat had been burned in a fire pit alongside the carpet knives, still in their packaging. This was not a crime of passion. This was an operation, a cleanup coordinated across multiple people and locations, carried out by people who understood exactly what they were trying to hide and why it mattered that they hide it. 2 years later, in a federal courtroom in Indianapolis, a jury looked at everything the government had assembled around that night and acquitted Anthony Spradley of the murder. Then the judge sentenced him to life in prison for it anyway. The charges that put him there were real. He was convicted by a jury of running a cocaine conspiracy that, according to the government's own witnesses, moved more than 500 kilograms of cocaine through Indianapolis between 1992 and 1997. Half a metric ton of cocaine built into a 5-year operation by a man whose only documented prior offense was a $2 fine. But the life sentence didn't come from the cocaine. It came from a murder the jury specifically refused to convict him of. And understanding how that happened requires understanding both the operation he built and the legal machinery that dismantled him in a way the jury never authorized. Indianapolis in the early 1990s was, by most national accounts, nowhere. People called it Naptown without irony, and the city's distance from the coastal markets that drove most drug coverage meant it existed in a kind of federal blind spot, even as the Department of Justice would later estimate that between 1,000 and 2,000 gang members were competing for control of its drug market, and 74% of adult arrestees were testing positive for illegal drugs against a national average of 67. The cocaine feeding that market arrived from Texas and Chicago through the highway system that made Indianapolis a secondary distribution center for the entire Midwest region, broken down by local crews and moved through a wholesale network that federal reports described as dominated by independent African-American organizations operating largely out of the national spotlight. By the mid-1990s, cocaine seizures and crime lab submissions in Indiana were climbing year over year as supply increased and prices fell, the unmistakable signature of a market that had matured well past its early stages, hidden in plain sight in a city the rest of the country had written off as quiet. Spradley built his operation inside that blind spot, and he did it so effectively that when prosecutors finally brought their case in 1999, the entire evidentiary foundation rested on the word of people who had been inside the organization with him, because there was almost nothing else. No major seizure ever traced back directly to him. No warehouse full of product, no intercepted shipment with his name on it. Just witnesses, ledgers pulled from a dumpster, and hundreds of thousands of dollars in cash and assets that couldn't be explained any other way. The jury heard all of it, convicted him of the drug conspiracy, and then drew a line the government was asking them to cross and refused. What happened after that refusal is the real story. The operation. 500 kilograms of cocaine is not a number that fits easily in the mind. A single kilogram weighs just over 2 pounds. 500 of them is more than 1,000 pounds of product. To move that weight over 5 years through a mid-sized Midwestern city with no major seizure ever traced back to you, that is not just a drug operation. That is a logistics problem, a supply chain, a management structure, and it has to survive personnel changes, law enforcement pressure, and the constant threat that someone inside it talks. The conspiracy Anthony Spradley ran between 1992 and 1997 did all of that. The Seventh Circuit Court of Appeals, reviewing the full trial record in 2002, described it as a large Indianapolis-based drug conspiracy involving the trafficking of hundreds of kilograms of cocaine, the accumulation and laundering of substantial profits. That language is measured and legal. The reality underneath it was 5 years of continuous operation, multiple co-defendants, rotating suppliers, and millions of dollars in cash and assets that had to be hidden from anyone looking. Spradley did not operate alone. The indictment filed in March 1998 named 6 co-defendants alongside him: Willie Body, Stephanie Johnson, Dennis Jones, Anthony Thompson, Ellis Walker, and Mark White. Spradley was listed as defendant number 1. Body was alleged to be his co-leader, the other name at the top of the structure, coordinating purchasing and distribution alongside Spradley. Jones served as a lieutenant, running logistics and transportation. Stephanie Johnson was the organization's financial face. Her name appeared on vehicle titles, property records, and purchase agreements, while the actual funds came from the operation. White was a mid-level presence, closely connected to the physical movement of product and cash. Thompson and Walker worked beneath them, receiving shipments and moving product through the local distribution network. Witnesses described Thompson waiting alongside other conspirators for cocaine shipments of 25 to 30 kilograms at a time, not handling a few grams on a corner, but standing by for bulk deliveries. The supply chain started well outside Indiana. Witnesses at trial described Spradley traveling to the Dallas area to purchase cocaine for later distribution in Indianapolis, tapping into the same pipeline of Mexican drug trafficking organizations, moving large quantities of cocaine from the Southwest through Indiana into the broader Midwest. Those shipments arrived in bulk. The typical individual transaction, based on cooperating witness testimony, ran 15 to 20 kilograms at a time. Terrence Pierce, a buyer who was not charged in the conspiracy, testified at trial that he personally watched Spradley purchase 15 kilograms from a supplier in a single transaction. One meeting, 15 kilograms changing hands. James Douglas, another cooperating witness who purchased from the organization, said Body delivered more than 5 kilograms to him alone over the course of several years. These were not isolated data points. They were the standard unit of commerce for this operation. The man who saw the most of it was Keith Cork, Spradley's assistant, his most trusted set of hands inside the operation. Cork was eventually arrested, agreed to cooperate with the government, and became the prosecution's most important witness. He testified that the conspiracy moved more than 500 kilograms of cocaine across his 5-year run. He knew the inner workings of the entire enterprise because he had been there for them. And when investigators pulled coded ledgers from a dumpster behind Spradley's home, Cork was the one who could explain what the numbers meant. A ledger showing a 20 next to a name meant 20 kilograms ready to sell. The columns of figures weren't accounting records for a legitimate business. They were inventory logs for a cocaine operation that never put his name on anything. The money that came out of those transactions had to go somewhere, and it couldn't look like drug money. The organization laundered its profits through vehicles, motorcycles, and real estate, all purchased in Stephanie Johnson's name using funds supplied by Spradley and Body. Investigators found evidence of extravagant purchases in Johnson's name amounting to over $500,000 in assets tied to the conspiracy, along with more than $350,000 in cash seized from Spradley, Jones, and associates during the pendency of the operation, cash that was never reclaimed because reclaiming it would have required explaining where it came from. At trial, Johnson testified under her cooperation agreement that the funds behind many of those purchases came directly from Spradley's stash. Her name was on the paperwork, his money was behind it. The legal buffer was thin, and by 1997 it was dissolving. One specific example made it into the trial record directly. A 1997 Ford Expedition purchased in Johnson's name with Spradley's funds in May of 1997. That same month, the operation was beginning to fracture from the inside. The fracture had started 6 months earlier, and it had a name. The informant, Marcus Willis, entered the conspiracy's orbit in November 1996. He was not a newcomer to the world the operation existed in. He was an associate, someone connected to the crew, someone they knew. And starting in November of that year, he was also working for federal law enforcement. For 8 months, Willis moved through Spradley's world wearing a wire. He built relationships, sat in on conversations, observed transactions, and fed information to DEA handlers. 8 months of access to a functioning cocaine organization passed back to investigators piece by piece. He watched Spradley oversee the transfer of 2 kilograms of cocaine from one vehicle to another, a transaction that co-conspirator William Cox later described to investigators in even greater detail, independently corroborating what Willis had reported. Willis put names to faces and faces to vehicles. He connected the operation to its suppliers. He was, by the time the conspiracy caught wind of him, an extraordinary asset and an extraordinary liability walking around inside the organization on borrowed time. Then the rumors started. Sometime in the spring of 1997, information began circulating inside the operation that Marcus Willis was talking to the feds. The source of those rumors isn't clear in the court record. What is clear is that by early June, Spradley knew about them. Several days before Willis's death, Spradley and Cork confronted Willis directly about the rumors, face to face, in a direct conversation about whether he was cooperating with law enforcement. Cork testified that during a meeting attended by several conspiracy members, Spradley said he would not let anyone hurt them, a statement the prosecution would later frame as a veiled threat to Willis specifically, and the defense would frame as evidence that Spradley was trying to defuse the situation rather than escalate it. What the court record confirms is this: Marcus Willis reported that confrontation to his DEA handlers on June 20th, 1997, 10 days before he was murdered. The system was warned. Federal agents knew their informant had been confronted by the head of the operation he was helping to bring down. They knew the organization suspected him, and 10 days later, on the night of Friday, June 27th, going into the early morning of June 28th, Willis was found fatally shot inside one of the defendant's vehicles, a white GMC Yukon parked in a strip mall lot near a nightclub called Mobile Jams on Keystone Avenue in Indianapolis. The forensic evidence told the story of what happened after the shooting in precise clinical detail. Willis's blood was found inside the Yukon, on the rear hatch, the door, and on floor mats that were later recovered separately after being removed from the vehicle. The front passenger seat had been removed. The carpet on the passenger side had been cut out. The left side of the front windshield was damaged. In the backyard of a garage on Caroline Street, police found the remains of a Yukon front seat burning in a fire pit, along with seatbelt parts, carpet knives still in their store packaging, and carpet samples that matched the Yukon's floor. Willis's blood was on the overhead door of that garage and on the floor inside. The evidence of a deliberate and organized cleanup was everywhere. Someone had spent real time and coordinated effort trying to make this vehicle unreadable as evidence, and they had not entirely succeeded. James Gibson was a conspirator not charged in the primary indictment. He had pleaded guilty to a related charge and agreed to testify. At trial, Gibson testified that after Willis was killed, He was directed to follow Dennis Jones as Jones drove the Yukon to Mobile Jams, and that after the murder, he was later sent to Atlanta to help conceal the vehicle. When Jones was arrested in that parking lot on the morning of June 30th, spotted by officers while driving the Yukon into the lot 3 days after Willis's body was found, Gibson fled and called Spradley directly to report that Jones was in handcuffs. Cork testified to the same basic sequence independently of Gibson. Both said Spradley orchestrated the cleanup. Both placed him at the center of the effort to eliminate the physical evidence connecting the organization to Willis's death. Neither one said they saw Spradley pull a trigger. Neither one could place him at the exact moment of the killing itself. And that absence, that specific, irreducible gap in the eyewitness chain, is what the jury grabbed hold of when deliberations were over. Marcus Willis was a human being who spent 8 months inside a dangerous operation gathering intelligence for the government. He held that position even after being confronted directly by the people he was informing on. He reported that confrontation to his handlers with 10 days left to live, and the system that asked him to carry that weight did not pull him out in time. Whatever the truth of what happened inside that Yukon on the night of June 27th, that part of the story deserves to sit with you before the legal proceedings begin. The verdict and the sentence that rewrote it. The federal indictment came down in March 1998, case number 198 CR 38, Southern District of Indiana. 7 defendants charged with conspiracy to distribute more than 5 kilograms of cocaine, money laundering, and in Spradley's case, the murder of an informant under 18 U.S.C. Paragraph 1512. Stephanie Johnson entered a guilty plea before trial and agreed to cooperate. The remaining defendants went to trial in 1999 before Judge Jane Magna Steinson in Indianapolis. The government's case rested almost entirely on cooperating witnesses. There was very little physical drug evidence, no warehouse full of kilos, no intercepted shipment traced directly to Spradley's hands. What the prosecution had was people: Cork, Pierce, Douglas, Gibson, and Johnson, all of whom had either pleaded guilty or agreed to testify in exchange for consideration at sentencing. The Seventh Circuit, reviewing that record 3 years later, described the testimonial evidence as overwhelming. Keith Cork alone testified that the conspiracy trafficked in more than 500 kilograms of cocaine and detailed 5 years of the operation's inner workings from the inside. Terrence Pierce placed Spradley at a 15-kilogram deal. The ledgers pulled from the dumpster showed 20 kilograms ready to move. The cash and the cars and the real estate told the story of where the money went. The defense attacked all of it on credibility grounds. Every cooperating witness had a deal with the government. Every quantity estimate came from someone who stood to receive a lighter sentence in exchange for helpful testimony. Defense attorneys pointed out that no physical cocaine was ever seized directly from Spradley. No seized bricks, no controlled deliveries, no drugs in a car or a home tied to his name. The 500-kilogram figure was a reconstruction assembled from the word of men who had every reason to give the government what it wanted. On the murder, the defense pointed to the conflicting eyewitness accounts and the absence of any evidence placing Spradley at the scene of the killing, and argued the jury should hold the government to the standard the law demanded. The jury convicted on the drug conspiracy and the money laundering. On the murder, they did not. On the murder, the 2 people who claimed to have been eyewitnesses, unindicted conspirator William Cox and defendant Mark White, gave accounts that could not be reconciled with each other and neither of which could be independently corroborated. The jury acquitted Spradley of every murder-related charge, not guilty on the charge of murdering a federal informant, not guilty on the aiding and abetting counts. 12 people looked at that evidence and decided the government had not cleared the bar of proof beyond a reasonable doubt. The jury convicted Spradley of the cocaine conspiracy and the money laundering counts. The murder, the crime they had just refused to convict him of, was off the table. That was the verdict. Then came the sentencing. Under the federal guidelines in effect in 1999, the guidelines were mandatory. Judges did not have discretion to simply impose what they thought was fair. They ran the calculation, and the calculation determined the sentence. The calculation for Spradley started with the drug quantity. The conspiracy involved well over 5 kilograms of cocaine, which set a high base offense level. Spradley also received a 4-level leadership enhancement for his role as an organizer. Those numbers alone would have produced an extraordinarily long sentence, the kind of sentence measured in decades rather than years, without any mandatory life term attached. But then the judge applied something called the murder cross-reference. Under USSG, paragraph 2D1.1D1, if a defendant's relevant conduct includes a killing that would constitute first-degree murder, the court is directed to sentence as though the defendant had been convicted of that killing, regardless of whether any jury ever agreed. Judge Magnus Steinson found by a preponderance of the evidence a far lower standard than beyond a reasonable doubt that Willis's murder was reasonably foreseeable to Spradley and that it was committed in furtherance of the conspiracy to protect the operation from further exposure. The jury's acquittal did not bind her. Under the law at the time, a judge could find facts the jury had rejected so long as the judge's own standard of proof, more likely than not, was met. That 51% threshold applied to a charge 12 people had rejected by a unanimous vote was enough to trigger a guideline that pushed the offense level to the top of the chart, equivalent to a first-degree murder conviction. The result was life imprisonment on the drug conspiracy count, plus a consecutive 20 years on the money laundering counts. A man with one prior conviction, a $2 gambling fine, was sentenced to die in federal prison for a murder a jury had specifically refused to convict him of. His co-defendants, who did not receive the murder cross-reference, were sentenced to 210 months, 327 months, and after Jones successfully challenged his sentence on appeal, eventually 235 months, same conspiracy. Spradley, life plus 20. The Seventh Circuit upheld the conviction and the sentence in 2002, holding that it was reasonably foreseeable to Spradley that Willis would be murdered with malice aforethought in an attempt to prevent him from further exposing the conspiracy. The practice that produced that outcome, using jury-acquitted conduct to drive a sentencing enhancement, was known as acquitted conduct sentencing, and it had been upheld by the Supreme Court in Watts versus United States, 519 U.S. 148, 1997, decided just 2 years before Spradley's trial. The logic, an acquittal, means the government didn't prove guilt beyond a reasonable doubt. It doesn't mean the conduct didn't happen. A judge could find it happened by a 51% standard and factor it into the sentence anyway. The gap between not proven to 12 jurors and factor into your punishment regardless was for decades perfectly legal. Spradley spent the next 2 decades challenging that outcome. A paragraph 2255 motion in 2005 denied. A paragraph 2241 petition in Kansas in 2017 arguing that a Supreme Court decision required a different causation standard for the murder enhancement, dismissed for lack of jurisdiction, with the court holding that Spradley should have raised the issue on direct appeal or his first habeas motion. A compassionate release motion in 2021, denied by the same judge who sentenced him in 1999, who cited the gravity of his crimes and his leadership role in the conspiracy. 25 years of legal arguments filed from inside a federal prison without a single successful outcome. While Spradley filed, his son grew up, Anthony Spradley Jr. was 5 years old when his father went to prison. He spent his childhood making sense of what a life sentence meant, wondering at a friend's house at age 5 whether the friend's father was coming back because his own father was gone and wasn't. At 10, he published a poem in a children's collection called Deepest Secrets, writing about carrying pain quietly and about the loneliness of being the kid without a father present. In November 2024, he published an essay through the FAMM Foundation, Families Against Mandatory Minimums, describing traveling across the country to visit his father at different federal facilities, 8-hour drives, arriving at the prison, getting turned away because of a minor dress code violation, and crying in the parking lot while his father stayed inside. His father, writing to him from prison, told him, "I will be home one day." His father's release date said, death. Then, two things happened in 2024 that changed the shape of the story. In April of that year, Judge Magnus Steinson, the same judge who had sentenced Spradley in 1999 and denied his 2021 compassionate release motion, granted his renewed motion. She found extraordinary and compelling reasons to reduce his sentence, citing his rehabilitation, the disparity between his punishment and what current law would produce, and the fact that he had already served more than 23 years. She reduced the sentence to approximately 300 months, which meant he had already served it. After a quarter century, Anthony Spradley walked out of federal prison. That same year, the United States Sentencing Commission voted unanimously to ban the exact practice that had produced his life sentence. Amendment 826 to the Federal Sentencing Guidelines, effective November 1st, 2024, added a new subsection stating that relevant conduct does not include conduct for which the defendant was criminally charged and acquitted in federal court. The commission struck the commentary that had cited Watts versus United States as authority. The chair of the commission said simply, "Not guilty means not guilty." What was done to Anthony Spradley in 1999, converting an acquittal into a life sentence through a 51% factual finding, is now prohibited under federal law. The amendment, however, is not retroactive. The roughly 2,000 people in federal custody who, like Spradley, were sentenced based on acquitted conduct cannot automatically petition for relief under the new rule. The commission considered making it retroactive and deferred that decision, citing the need for guiding principles and concerns about forcing courts to relitigate decades-old evidence. As of mid-2026, no retroactivity designation has been issued. Multiple Supreme Court justices, Sotomayor, Kavanaugh, Gorsuch, Barrett, have questioned the constitutional legitimacy of acquitted conduct sentencing in written opinions, and new petitions are still being filed asking for a definitive ruling on whether the practice violates the Sixth Amendment right to a jury trial. The rule is gone for future defendants. The sentences built under it remain, and the constitutional question is still open. Anthony Spradley ran a cocaine operation that, by the testimony of his own inner circle, moved somewhere north of 500 kilograms through Indianapolis over 5 years. That is documented, it is in the federal record, and the jury found him guilty of it beyond a reasonable doubt. That guilt is not in dispute here. What is in dispute, what the jury disputed at trial, what critics of the sentencing system disputed for decades afterward, and what the Sentencing Commission finally resolved in 2024 is whether a jury's verdict of not guilty is supposed to mean anything at all. Whether the government, having failed to prove something to 12 people applying the highest evidentiary standard the law provides, gets to come back through a side door and impose the punishment for it anyway. Spradley's son is in his 30s now. His father is free. The policy that put him in prison for life on a murder charge a jury refused to sustain has been abolished. And somewhere in between all of those facts sits the body of Marcus Willis, still in that Yukon, still waiting for an answer the courts never had to give.